Chapter 1. Basis of the Equity Jurisdiction of the Circuit Courts of the United States. 1. Introductory. 2. Creation of the Federal Judiciary. 3. Constitutional grant of judicial power. 4. Statutory grants of jurisdiction. 5. Original jurisdiction of the Circuit Courts of the United States. -6. Same jurisdiction under the Bankruptcy Act. Lee 7. Sources of the equity jurisdiction of the Circuit Courts of the United States. 8. The system of equity jurisdiction and jurisprudence administered by the Circuit Courts. 9. Same rules of decision same in all the states. 10. Adequate remedy at law. 11. The jurisdiction must appear upon the face of the record. 1. Introductory in every suit commenced, and prosecuted in the courts of the United States the jurisdiction 6 null facts must affirmatively appear upon the face of the record. 1. A knowledge of correct procedure is inseparably connected with a knowledge of the peculiar limitations established upon the judicial power of the government. It therefore follows, as a logical necessity, that the acquisition of a comprehensive understanding of the great system of equity procedure administered in the Circuit Courts of the United States and its actual application in judicial controversies, demand, as a prerequisite, a clear conception of the nature, origin, and sources of the equity jurisdiction vested in those courts. It is an axiomatic legal truth that the basis of this equity jurisdiction is laid in the provisions of the federal constitution and the laws made under the authority thereof, creating the federal judiciary, and granting and limiting the judicial power of the United States, and 1 Continental Life-Ins. Co. v. Rhodes, 119 U.S. 237, Pepper v. Fordyce, 119 U.S. 469, Johnson v. Christian, 125 U.S. 645. 1. 2 Federal equity procedure. 1. Referring and determining the jurisdiction of the courts of the federal judicial system, and all intelligent study of procedure, and especially equity procedure, in the federal courts, should, in the very nature of things, be preceded by a critical examination of these constitutional and statutory provisions. The importance of the preliminary investigation here suggested is evidenced by the fact that a great body of judicial learning, the accretions of a century, has been developed by the judges of the courts of the United States touching their jurisdiction, which learning has been devoted largely to the construction and practical application of these constitutional and statutory provisions to the affairs of human society in controversies eris. Before them. There has been little or no difficulty in holding that the equity powers of the circuit courts are amply sufficient to administer full relief in all cases falling within their equity jurisdiction. The chief difficulty has been encountered in determining whether or not the particular case before the court for adjudication came within the class of controversies over which the court has been, by the Constitution and laws, given jurisdiction. This has resulted from the peculiar limitations established by the Constitution upon the judicial power of the United States. In Bank v. Devox 1 Chief Justice Marshall said, the judicial power of the United States, as defined in the Constitution, is dependent, first, on the nature of the case, and second, on the character of the parties. And in Cohens v. Virginia the same learned judge said, in one description of cases the jurisdiction of the court is founded entirely on the character of the parties, and the nature of the controversy is not contemplated by the Constitution. The character of the parties is everything, the nature of the case nothing. In the other description of cases the jurisdiction is founded entirely on the character of the case, and the parties are not contemplated by the Constitution. In these the nature of the case is everything, the character of the parties is nothing. It is not within the purview of this work to discuss the principles of equity jurisprudence, nor to enumerate the rights and estates which are cognizable in courts of equity, but it seems reasonable to direct attention, in the inception, to the provisions of conventional law, which form the basis of the equity jurisdiction. I-5 Cranch, 85, 2, 6 Wheat 264. 2, 3, Basis of equity jurisdiction 3. Cheyenne of the Circuit Courts of the United States, as introductory to the study of equity procedure in those courts. 2. Creation of the federal judiciary. The federal constitution provides that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior court as the Congress may from time to time ordain and establish. 1. By the Judiciary Act of September 24, 789, to the Congress create ordained and established district courts and circuit courts, and under this act the judiciary system of the United States was fully organized, and went into immediate active operation, by Act of February 24, 1855. 3. The Court of Claims was created and established, and by the Act of March 8, 1891, 4. The Congress created, ordained, and established a United States Circuit Court of Appeals in, and for each circuit, and under the Act these courts were at once organized, and went into a point court of operation. The circuit courts of the United States are not inferior courts in the common law or technical sense, they are so only in the sense of the federal constitution, and in subordinity unto the Supreme Court, and their judgments and proceedings are not to be regarded and interpreted in the light of the common law rules applicable to inferior common law courts. 5.3. Constitutional grant of judicial power. The constitutional grant of judicial power is as follows. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority, to all cases affecting ambassadors or other public ministers and consuls, all cases of admiralty and maritime jurisdiction. To controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, and citizens of the same state claiming lands under grants of different states, and between a state, or citizens thereof, and foreign states, citizens or subjects. 1 U.S. Const. Art 3, Seconds 1. 21 U.S. Statute L. Chapter 20, p. 73 et sec. 3 U.S.R.S. Seconds 1040 et sec. 4. 26 U.S. Statute L. Chapter 517, p. 828 et sec. 5 Livingston Point on v. Van Ingen, 1 Payne, 45, Fed. Cass. Number 8420, Turner v. Bank of North America, 4 Doll 8, McCormick v. Sullivan, 10 Wheat, 192, Kemp's Lessees v. Kennedy, 5 Cranch, 173. 4 Federal Equity Procedure. 4. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases, before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions, and under such regulations as the Congress shall make. 1. To meet the decision of the Supreme Court in the case of Chisholm v. Georgia. 2. And to place a limitation upon the judicial power in that regard. The Constitution was amended as follows. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. 3. It will be seen that, although the Constitution has defined the limits of the judicial power of the United States, yet it has not prescribed how much of that power shall be exercised by the circuit courts, nor defined their jurisdiction, leaving this to be determined by Act of Congress. 4. Statutory grants of jurisdiction. The Judiciary Act of September 24, 1789, 5 conferred upon the circuit courts original jurisdiction, concurrent with the courts of the several states, of all suits of a civil nature, at common law and in equity, in certain classes of controversies enumerated in that statute. Subsequent legislation conferred additional jurisdiction upon the circuit courts. These statutes, with their amendments, were revised, consolidated, and carried into the revised statutes. S after the revision, and on March 3, 1875, an act was passed by Congress entitled An Act to determine the jurisdiction of the circuit courts of the United States and to regulate the removal of causes from state courts, and for other purposes. 7. This act was amended March 3, 1887. 8. And the last named act was amended August 13, 1888. 9. The act of March 3, 1875, did not repeal or displace any part of Section 629 of the revised statutes, except the first paragraph thereof, and the acts of March 3rd. TUS Const. Art 3, Seconds 2. 22 all 419. 3 U.S. Const. 11th Amend. 4 Sheldon v. Searle. 8 Howe 446. Smith v. Jackson. 1 Payne. 453. Fed. Cass. Number 13064. 5. 1 U.S. Stat at L. Chapter 20. P 73 et sec. 6 USRS. Second 629 et sec. 7. 18 U.S. Street Pointed at L. Chapter 137. S 24 U.S. Stat at L. Chapter 373. 9. 25 U.S. Stat at L. Chapter 866. 5.J Basis of Equity Jurisdiction 5. 1887, and of August 13, 1888, being a mandatory of the Act of March 3, 1875, said Section 629 of the revised statutes, except the first paragraph, remains in full force. 1. The general jurisdiction of the circuit courts of the United States is now defined and determined by Chapter 7 of Title 13 of the United States Revised Statutes, and the 3 acts of Congress last above named. There are some other special statutes giving jurisdiction to the circuit courts. 5. Original jurisdiction of the circuit courts of the United States. The circuit courts of the United States have original jurisdiction in the filing suits, namely, 1. Of all suits of a civil nature, at common law or in equity, where the matter in dispute exceeds, exclusive of interest and costs, the sum or value of $2,000. And arising under the Constitution or laws of the United States, or treaties made, or which shall be made under their authority. 2. Of all suits of a civil nature, at common law or in equity, in which the United States are plaintiffs or petitioners, in which there shall be a controversy between citizens of the same state, claiming lands under grants of different states, without regard to the sum or value of the matter in dispute. 5. Of all suits of a civil nature, at common law or in equity, in which there shall be a controversy between citizens of a state and foreign states, citizens or subjects, in which the mat. I. Milamajico v. Carpenter, 34 Fed. R. 433, White v. Rankin, 144 U.S. 628, American Englishes v. Hager, 36 Fed. R. 129, Armstrong v. Etelson, 36 Fed. R. 209, Armstrong v. Trantham, 36 Fed. R. 275, McConville v. Gilmer, 6 Fed. R. 277. 225 U.S. Stat at L, Chapter 866 Seconds 1, P. 434, United States v. Saywood, 160 U.S. 493, 498. 3. 25 U.S. Stat at L, Chapter 866, Seconds 1, P. 434, United States v. Saywood, 160 U.S. 494. 4. 25 U.S. Stat at L, Chapter 866, Seconds 1, P. 434. 5. 25 U.S. Stat at L, Chapter 866, Seconds 1, P. 434, United States v. Saywood, 160 U.S. 494. 6. Federal Equity Procedure. 5. Terra in dispute exceeds, exclusive of interest and costs, the sum or value of $2,000. 1. 6. Of all suits commenced by the United States, or by direction of any officer thereof, against any national bank, or suits for winding up the affairs of any such bank, without regard to the sum, or value of the matter in dispute. 2. 7. Of all suits at law or FO equity, arising under any act providing for revenue from imports or tonnage, except civil causes of admiralty and maritime jurisdiction, and seizures on land, or on waters not within admiralty and maritime jurisdiction, and except suits for penalties and forfeitures, of all causes arising under any law providing internal revenue. and of all causes arising under the postal laws, without regard to the amount or value of the matter in dispute. 3. 8. Of all suits and proceedings for the enforcement of any penalties provided by laws regulating the carriage of passengers in merchant vessels, without regard to the amount or value of the matter in dispute. 4. 9. Of all proceedings for the condemnation of property taken as prize, in pursuance of section 5308, title insurrection, without regard to the amount or value of the matter in dispute. 5. 10. Of all suits for the enforcement of forfeitures, and for the seizure or condemnation of any property under any law relating to the slave or coolie trade, without regard to the amount or value of the matter in dispute. 6. 11. Of all suits by the assignee of any debenture for drawback of duties, issued under any law for the collection of duties against the person to whom such debenture was originally granted, or against any endorser thereof, to recover the amount of such debenture, without regard to the amount or 1' of the matter in dispute. 7. 12. Of all suits at law, or in equity arising under the patent or copyright laws of the United States, without regard to the sum or value of the matter in dispute. 8. L. 25 U.S. Statute L. Chapter 866, Sections 1, p. 434. 2. 25 U.S. Statute L. Chapter 866, Sections 4, p. 436. AU. SRS, Second 629. 4 USRS, Sex 629, 4270, 4540 and 4610. 5 USRS, Sex 629, 5308, 5309. 6 USRS, Sex 629, 2159, 5555, 5556. 7 USRS, Sex 629, 3039. Su. SRS, Sex 629, 4970, White v. Rankin, 144 U.S. 628, Belford v. Scribner, 144 U.S. 488. 5. Basis of equity jurisdiction. 7. 13. Of all suits brought by any banking association established in the district for which the court is held under the provisions of Title the National Banks, to enjoin the controller of the currency, or any receiver acting under his direction, as provided in said title, without regard to the amount or value in dispute. 1. 14. Of all suits brought by any person, to recover damages for any injury to his person or property on account of any act done by him, under any law of the United States for the protection or collection of any of the revenue thereof, or to enforce the rights of citizens of the United States to vote in the several states, without regard to the amount or value of the matter in dispute. 2. 15. Of all suits to recover possession of any office, except that of elector of president or vice president, representative or delegate in Congress, or member of state legislature, authorized by law to be brought, wherein it appears that the sole question touching the title to such office arises out of the denial of the right to vote to any citizen offering to vote, on account of race, color or previous condition of servitude, provided that such jurisdiction shall extend only so far as to determine the rights of the parties to such office by reason of the denial of the right guaranteed by the Constitution of the United States, and secured by any law, to enforce the right of citizens of the United States to vote in all the states. 3. 16. Of all proceedings by writ of quo warranto, prosecuted by any district attorney, for the removal from office of any person holding office, except as a member of Congress, or of a state legislature, contrary to the provisions of the 3rd section of the 14th article of amendment to the Constitution of the United States. 4. 17. Of all suits to recover pecuniary forfeitures under any act, to enforce the right of citizens of the United States to vote in the several states. 5. 18. Of all suits authorized by law, to be brought by any person to redress the deprivation, under any color of any law, statute, ordinance, regulation, custom or usage of any state, of LUSRS, Sex 629, 5237. 2 TR. SRS, Second 629. AU. SRS, Sex 629, 2010. 4 USRS, Sex 629, 1786. 6 USRS, Second 629. 8 Federal Equity Procedure. 5. Any right, privilege or immunity secured by the Constitution of the United States, or of any right secured by any law providing for equal rights of citizens of the United States, or of all persons within the jurisdiction of the United States. 1. 19. Of all suits authorized by law, to be brought by any person on account of any injury to his person or property, or of the deprivation of any right or privilege of a citizen of the United States, by any act done in furtherance of any conspiracy, mentioned in Section 1980, Title Civil Rights. 2. 20. Of all suits authorized by law to be brought against any person who, having knowledge that any of the wrongs mentioned in Section 1980 are about to be done, and having power to prevent, or aid in preventing the same, neglects or refuses so to do, to recover damages for any such wrongful act. 3. 21. Of all proceedings within their respective districts for the condemnation of real estate for use by the United States government. 4. 22. Of suits against the government of the United States, concurrent with the Court of Claims, to determine all claims founded upon the Constitution of the United States or any law of Congress, except for pensions, or upon any regulation of an executive department, or upon any contract, expressed or implied, with the government of the United States, or for damages, liquidated or unliquidated, in cases not sounding in tort, in respect of which claims the party will be entitled to redress against the United States either in a court of law, equity or admiralty, if the United States were suable, and of all set-offs, counterclaims, claims for damage, liquidated or unliquidated, or other demand whatsoever on the part of the government of the United States against any claimant against the government in said courts, where the amount of such claim exceeds $1,000, and does not exceed $10,000, provided, said courts shall not have jurisdiction to hear and determine war claims, or any other claims which were rejected or reported on adversely by any court, department, or commission authorized to hear and determine the same prior to March 3, 1887. 5. 1 USRS, Sec. 629, 1979. 2 USRS, Second 629. AU. SRS, Sec. 629, 1081. 25 U.S. Stat L, Chapter 728, p. 357. 5. 24 U.S. Stat L, O 359, p. 505, United States v. Jones, 131 U.S. 1, United States v. Drew, 131 U.S. 21. 6.J.B.Cs of Equity Jurisdiction. 9. 23. Of suits for the recovery of the penalty of $1,000 for any violation of the act prohibiting the importation and migration of foreigners and aliens under contract or agreement to perform labor in the United States, its territories and District of Columbia. 1. 24. Of suits by the United States for the recovery of the possession of their public lands held by persons and corporations in violation of the act, to prevent unlawful occupancy of such lands. 2. 25. Of proceedings to review the decision of questions of law and of fact made by the General Board of Appraisers in determining the classification of merchandise imported into the United States and the rate of duty due thereon under such classification. 3. 26. Of suits in equity, to restrain violations of the acts, to protect trade and commerce, and the import trade, against unlawful restraints, agreements, trusts, monopolies and conspiracies. And of suits for damages brought by any person injured in his business or property against any other persons or corporations done by them, and forbidden or declared unlawful by said acts, without respect to the amount in controversy. 4. 2 feet 7. Of suits in equity, brought by one tenant in common, or joint tenant for partition of lands in cases where the United States are one of such tenants, such suit to be bro/.GHT in the district where the land is situated. 5. 6. Same jurisdiction under the Bankruptcy Act. The Bankruptcy Act contains the following provisions. The United States Circuit Courts shall have jurisdiction of all controversies at law and in equity, as distinguished from proceedings in bankruptcy, between trustees as such, and adverse claimants concerning the property, acquired or claimed by the trustee. in the same manner, and to the same extent only. 123 U.S. Stat at L, Chapter 164, p. 332. 26 U.S. Stat at L, Chapter 551, p. 1084, United States v. Mexican Nat. Ry. Co. 40 Fed. R. 769, United States v. Whitcomb Metallic Bedstead Co. 45 Fed. R. 89. 2. 23 U.S. Stat at L, Chapter 149, p. 321. A 26 Stat at L, Chapter 407, Seconds 15, p. 138. Second, Rita Kerho, FF, 45 Fed. R. 235, in re Blumlein, 45 Fed. R. 236, in re Downing, 45 Fed. R. 412. 4. 26 U.S. Stat at L, Chapter 647, p. 209. 28 U.S. Stat at L, Chapter 349, Sec 73-77, p. 570, United States v. Jellicoe Mountain Coal and Coke Co., 46 Fed. R. 432. 5. 30 U.S. Stat at L, Chapter 339, p. 416. 10 Federal Equity Procedure. 7. 8. As though bankruptcy proceedings had not been instituted, and such controversies had been between the bankrupts and such adverse claimants. B. Suits by the trustees shall only be brought, or prosecutted in the courts where the bankrupt, whose estate is being administered by such trustee, might have brought, or prosecutted them, if proceedings in bankruptcy had not been instituted, unless by consent. 1. 7. Sources of the equity jurisdiction of the Circuit Courts of the United States. The equity jurisdiction of the Circuit Courts is dependent alone upon the Constitution and laws of TH and United States. On this point the terse and comprehensive language of Judge McCrary are here given. It has long been settled that the jurisdiction of the Circuit Courts of the United States in equity is derived from, and defined by the Constitution and laws of the United States, that it is the same in all the states, and is not affected or varied by the various statutes of the states whereby the chancery powers and jurisdiction of state courts may be defined and regulated. This court cannot, therefore, look to any state legislation as the source of its equity jurisdiction. The jurisdiction of the courts of the United States is derived alone from the Constitution and laws of the United States, and cannot be enlarged, diminished or affected by state laws or regulations. The local laws of a state can never confer jurisdiction on the courts of the United States. They can only furnish rules to ascertain the rights of the parties, and thus assist in the administration of the proper remedies, where the jurisdiction is vested by the laws of the United States. 8. The system of equity jurisdiction and jurisprudence, and administered by the circuit courts. The remedies in the circuit courts of the United States are at common law or in I-30 U.S. Stat at L, Chapter 541, Seconds 23, p. 544. 2 Strettel v. Borlo, 9 Fed. R. 256, American Assen, Lim, v. Eastern Kentucky Land Co., 68 Fed. R. 721, United States v. Drennan, Hemp, 320, Fed. Os. Number 14992, The Orleans v. Phobos, 11 Pet 175, Carey, v. Curtis, 3 How 1 !93, Livingston v. Jefferson, 1 Brock 203, Fed. Cass. No. 8411, Scott v. Sanford, 19 How 393, 633, Scott v. Naley, 140 U.S. 106, Gormley v. Clark, 134 U.S. 338, Redings v. Johnson, 128 U.S. 212, New Orleans v. Louisiana Construction Co., 129 U.S. 145, Scott v. Armstrong, 146 U.S. 499, Northern Pac. R. Co. v. Payne, 119 U.S. 561. 9. Basis of equity jurisdiction. 11. Equity not according to the jurisdiction and procedure of the state courts, but according to the principles of common law and equity, as distinguished and defined in that country from which we have derived our knowledge of those principles. The equity jurisdiction and equity jurisprudence administered in the circuit courts of the United States are coincident and coextensive with that exercised in England, and are not regulated by the municipal jurisprudence of the states where the court sits. And, the settled doctrine of the Supreme Court of the United States is, that the remedies I0, equity are to be administered, not according to THR state practice, but according to the practice of the courts of equity in the parent country, as contradistinguished from the courts of common law, subject, of course, to the provisions of the Act of Congress, and to such alterations and rules as, in the powers delegated in those acts, the courts of the United States may from time to time prescribe. Arid circuit courts of the United States will exercise their equity jurisdiction, and apply their equitable remedies for the protection and preservation of equitable rights and estates. Alt/lock the state, where the court sits does not exercise a like jurisdiction nor administer like remedies. 9. Same rules of decision same in all the states. The equity jurisdiction given by the Constitution and laws of the United States to the circuit courts being the same in all the states of the Union, their rules of decision are the same in all the states, and the decisions of state courts involving only the general principles of equity, and not controlled by local law or usage, are not binding authority on the courts of TQ.E. United States 2, but the title to real estate and a construction of deeds and statutes in respect thereto are matters of local law, and the Supreme Court of the United States follows as a rule the decisions of the highest court of the state in regard to the L. Robinson v. Campbell, 3 Wheat, 212, Boyle v. Zachary, 6 Pet 658, United States v. Howland, 4 Wheat, 115, Neves v. Scott, 13 How 271, Story v. Livingston, 13 Pet 357, Noonan v. Lee, 2 Black, 409, Fletcher v. Maury, 2 Story, 555, Fed. Cass. No. 4864, 2 Neves v. Scott, 13 How 268, United States v. Howland, 4 Wheat, 115, Boyle v. Zachary, 6 Pet 658, Robinson v. Campbell, 3 Wheat 222, Livingston v. Story, D. Pet 654, Russell v. Southard, 12 How 239, 12 Federal Equity Procedure, 10. Same, and the law of a state as declared by its Supreme Court is controlling as a rule of property. 110. Adequate remedy at law. The 16th Sect 10N of the original Judiciary Act declared that suits in equity shall not be sustained in either of the courts of the United States, in any case where clean, adequate and complete remedy may be had at law. To this legislation introduced no new rule in regard to the limitation upon equitable remedies. It is simply declaratory of the rule which has existed in England ever since the adoption of equitable remedies in that country, and the adequate remedy at law, the absence of which is, by this statute, made the test of equitable jurisdiction in the courts of the United States, is that which existed at the time the statute was adopted, unless changed by subsequent legislation. 3. In this rule, as interpreted by the Supreme Court of the United States, is that whenever a court of law is competent to take cognizance of a right, and has power to proceed to a judgment which affords a clean, adequate and complete remedy, without the aid of a court of equity, the plaintiff must proceed at law, because the defendant has a constitutional right to a trial by jury, for the statutory declaration of the rule was intended to emphasize it, and to impress it upon the attention of the courts. 5. In order to defeat the equity jurisdiction, the remedy at law must be as practical and as efficient to the ends of justice and its prompt administration, both in respect to the final relief and the mode of obtaining it, as the remedy which equity would confer under the same circumstances. 6. I. Halstead v. Buster, 140 U.S. 273, Corner Water Power Co. v. Green Bay and M. Canalco, 124 U.S. 254, Bacon v. Northwestern Mutt, Life Ins. Co. 131 US 258, Hanrig v. Patrick, 110 US 156, Ridings v. Johnson, 128 US 212, Clement v. Parker, 125 U.S. 309, Gormley v. Clark, 134 US 338, Parker v. Dackers, 130 US 43, Byers v. Macaulay, 149 US 608, Peters, Bain, 133 US 670, Street, Louis v. Rutz, 138 US 226, Barney v. Keokuk, 94 US 324, Parker v. Burt, 137 US 661, Hardin v. Jordan, 140 US Isle 71, Cross v. Allen, 141 US 528, Jenks v. Quidnick Co., 135 US 457. 2. 1 US Stat at L, Chapter 20, Second 16, P82, USRS, Second 723. 3. McConaughey v. Wright 121 US 201, Whitehead v. Shattuck, 138 US 146. 4. Buzard v. Houston, 119 US 347, Hip v. Babin, 19 How 271, Lewis v. Cox, 23 Wall 466, Road v. Railway Co., 105 US 189, Killian v. Ebbinghorse, 110 US 568, SNY Guarantee Co. v. Memphis Water Co., 107 US 205, T. Tyler v. Savage, 143 US 79, Kill. 11. J. Basis M. Equity Jurisdictio 13. 11. The jurisdiction must appear upon the face of the record. The jurisdiction of the circuit court is limited, in the sense that it has no jurisdiction other than that conferred upon it by the Constitution and laws of the United States, and, as a result of this limitation upon the jurisdiction, the presumption is that a cause is without its jurisdiction, unless the contrary affirmatively appears. It has long been settled that the facts upon which the jurisdiction of the circuit courts rests must, in some form, appear upon the face of the record in all suits prosecuted before them, and it is error for the court to proceed until its jurisdiction is shown. 1 Chief Justice Taney, discussing the necessity of the record showing the jurisdiction, and the reason of the rule, said, but in making this objection, we think the peculiar and limited jurisdiction of courts of the United States has not been adverted to. This peculiar and limited jurisdiction has made it necessary, in these courts, to adopt different rules and principles of pleading, so far as jurisdiction is concerned, from those which regulate courts of common law in England, and in the different states of the Union which have adopted the common law rules. In these last mentioned courts, where their ch1tr actor and rank are analogous to that of a circuit court of the United States. In other words, where they are what the law terms courts of general jurisdiction, they are presumed to have jurisdiction, unless the contrary appears. No averment in the pleadings of the plaintiff is necessary, in order to give jurisdiction. If the defendant objects to it, he must plead it specially, and, unless the fact on which he relies is found to be true by a jury, or admitted to be true by the plaintiff, the jurisdiction cannot be disputed in an appellate court. Now, it is not necessary to inquire whether in courts of that description a party who pleads over in bar, when a plea to the juris. Bourne v. Sunderland, 130 US 505. 393 et sec. Fishback v. Western Boyce v. Grundy, 3 Pet 210, Sully Union Teleg. Co. 161 US 96, Stevens Van v. Portland and KRR Co. 94 v. Nichols, 130 US 230, Chapman v. US 806, Wally v. Koch, 15 How 415. Barney, 129 US 677, Cameron v. I Continental Lifelines Co. Point v. Rhodes, Hodges, 127 U.S. 322, Anderson 119 U.S. 237, and authorities cited, v. Watt, 138 U.S. 694, Tennessee v. Railway Co. v. Swan, 11 U.S. 379, Union and P. Bank, 152 U.S. 454, Met Grace v. American Cent. Inns. Co. 109 Cuff v. Watertown, 128 U.S. 586, U.S. 278, Scott v. Sanford, 19 Howe. 14 Federal Equity Procedure. 11. Diction has been ruled against him, does or does not waive his plea, nor whether upon a judgment in his favor on the pleas in bar, and a writ of error brought by the plaintiff, the action upon the plea in abatement, would be open for revision in the appellate court. Cases that may have been decided in such courts, or rules that may have been laid down by common law pleaders, can have no influence in the decision in this court. Because, under the Constitution and laws of the United States, the rules which govern the pleadings in its courts, in questions of jurisdiction, stand on different principles, and are regulated by different laws. This difference arises, as we have said, from the peculiar character of the government of the United States. For although it is sovereign and supreme in its appropriate sphere of action, yet it does not possess all the powers which usually belong to the sovereignty of a nation. Certain specified powers, enumerated in the Constitution, have been conferred upon it, and neither the legislative, executive nor judicial departments of the government can lawfully exercise any authority beyond the limits marked out by the Constitution. And in regulating the judicial department, the cases in which the courts of the United States shall have jurisdiction are particularly and specifically enumerated and defined, and they are not authorized to take cognizance of any case which does not come within the description therein specified. Hence, when a plaintiff sues in a court of the United States, it is necessary that he should show, in his pleading, that the suit he brings is within the jurisdiction of the court, and that he is entitled to sue there. And if he omits to do this, and should, by any oversight of the circuit court, obtain a judgment in his favor, the judgment would be reversed in the appellate court for want of jurisdiction in the court below. The jurisdiction would not be presumed, as in the case of a common law English or state court, unless the contrary appeared. But the record, when it comes before the appellate court, must show, affirmatively, that the inferior court had authority, under the Constitution, to hear and determine the case. 1. I. Scott v. Sanford, Supra. Chapter 2. System and Sources of Equity Procedure administered in the Circuit Courts of the United States. 12. Statutes adopting and regulate Court of Chancery and equity procedure in the land. United States Circuit Courts. 19. Circuit Courts may make equity. 13. Supreme Court authorized by rules. Statute to make equity rules. 20. Equity procedure same in all 14. First equity rules promulgated the states. By the Supreme Court. 21. Authorities upon equity pro. 15. Same rules now in force procedure in the circuit courts. 16. Procedure of the High Court. 22. Same Chancellor Kent's opinion of Chancery in England irons. Adopted. 23. Ancient English equity plead. 17. Same explanation of equity eyeing. Rule 90 by the Supreme Court. 24. The matured English equity. 18. Same orders of the high pleading. 12. Statutes adopting and regulating equity procedure in the United States Circuit. The original Judiciary Act is silent upon the subject of equity procedure. The Act to regulate process in the courts of the United States, approved September 29, 1789, just 5 days after the approval of the Judiciary Act, provided that the forms and modes of proceedings in causes of equity, and of admiralty and maritime jurisdiction shall be according to the course of the civil law, 1 by Section 2 of an Act approved May 8, L. 792, to it was declared, that the forms of writs, executions and other process, and the forms and modes of proceedings in suits of equity and admiralty and maritime jurisdiction, shall be according to the principles, rules, and usages which belong to courts of equity and courts of admiralty, respectively, as contradistinguished from courts of common law, subject to such alterations and additions as the said courts respectively shall in their discretion deem expedient, or to such regulations as the Supreme Court of the United States shall think proper from time to time by rule to prescribe to any circuit or district court concerning the same. 11 U.S. Statute L. Chapter 21, Sections 2, pages 93, 94. 21 U.S. Statute L. Chapter 36, Sections 2, p. 276. 16 Federal Equity Procedure. 13, 14. Additional legislation was had upon the subject by acts of Congress approved May 19, 1828, August 1, 1842, and June 1, 1872, respectively. These various acts were revised and consolidated, and carried into the revised statutes in the following form: the forms of measure and process and the forms and modes of proceedings in suits of equity, and of admiralty and maritime jurisdiction in the circuit and district courts shall be according to the principles, rules, and usages which belong to courts of equity and of admiralty, respectively. Except when it is otherwise provided by statute, or by rules of court made in pursuance thereof, but the same shall be subject to alteration and addition by the said courts, respectively, and to regulation by the Supreme Court, by rules prescribed, from time to any circuit or district court, not inconsistent with the laws of the United States. 113. Supreme Court authorized by statute, to make equity rules. Their Act of May 8, 1792, authorized the Supreme Court to prescribe rules to the circuit and district courts in suits in equity and admiralty, and this authority was amplified and extended by subsequent statutes. The legislation upon the subject, as revised and consolidated, is as follows: the Supreme Court shall have power to prescribe, from time to time, and in any manner not inconsistent with any law of the United States, the forms of writs and other processes, the modes of framing and filing proceedings and pleadings, of taking and obtaining evidence, of obtaining discovery, of proceedings to obtain relief, of drawing up, entering and enrolling decrees, and of proceedings before trustees appointed by the court, and generally to regulate the whole practice to be used in suits in equity or admiralty by the circuit and district courts. 2. 14. First equity rules promulgated by the Supreme Court. In March, 1822, the Supreme Court, under the authority given to it by the Act of May 8, 1792, promulgated 33 rules, to be the rules of practice for the courts of equity of the United States. These rules provided for the holding of monthly rules in the clerk's office on the first Monday in every month, and the regulation of the filing of pleadings. The IUSRS, Sections 913, 2 USRS, Sections 917. 15-17. J. System and Sources of Equity Procedure 17. Issue, execution, and return of process, the taking of decrees Pt confesso, the regulation of proceedings in the masters of vice, and the taking of testimony, but those rules covered but few points of practice, and were, in several respects, materially variant from the equity rules now in force. 115. Same rules now in force. On March 2, 1842, the Supreme Court promulgated 91 equity rules, to take effect August 1, 1842, and which, with a few amendments and additions, are now in force in the circuit courts of the United States. These rules supersede the rules of March 1822, and regulate, to some extent, and in all particulars, almost every step, and proceeding in suits in equal point from their commencement to their conclusion. Many of them were taken from the English Chancery orders then in force. 16. Procedure of the High Court of Chancery in England adopted Equity Rule 33, adopted March 1822, is as follows: in all cases where the rules prescribed by this court, or by the circuit court, do not apply, the practice of the circuit courts shall be regulated by the practice of the High Court of Chancery in England. The Act of May 8, 1792, and the rule just quoted, were effectual to adopt the equity procedure of the English High Court of Chancery in all cases not covered by a law of Congress or rule of court. To Equity Rule 90, adopted March 2, 1842, is as follows. In all cases where the rules prescribed by this court, or by the circuit court do not apply, the practice of the circuit court shall be regulated by the present practice of the High Court of Chancery in England, so far as the same may reasonably be applied, consistently with the local circumstances and the local conveniences of the district, where the court is held, not as positive rules, but as furnishing just analogies to regulate the practice. 17. Same explanation of Equity Rule 90 by the Supreme Court, between March, 1822,